Good morning. Welcome to this installment of the Pro Bono Partnership of Atlanta's monthly webcast series. My name is Sarisha Ganta. I'm an attorney with the partnership, and I'm excited here today to have Dave Matthews and Jake Gilbert here to speak to us about EPLI. What is it? And does my nonprofit need it? And today we have two experts here to speak to us about the topic. Dave is Executive Vice President at Pritchard & Jordan. And when he's not consulting with his clients on risk management, he serves on numerous nonprofit boards and is very active in the nonprofit community of Atlanta. Jade is an associate at Seyfarth Shaw in their labor and employment division, and she too is actively involved with nonprofits providing pro bono legal services. To tell you a little bit about our organization, the Pro Bono Partnership of Atlanta provides free legal assistance to community-based nonprofits that serve low-income or disadvantaged individuals. We match eligible organizations with volunteer lawyers from the leading corporations and law firms in Atlanta who can assist nonprofits with their business law matters. Our clients are 501c3 organizations that are located and serve Greater Atlanta, who serve low-income or disadvantaged individuals and are otherwise unable to afford legal services. If you're interested in becoming a client or learning more about our organization, please visit our website. The website also has a lot of great information and articles and webcasts, including this webcast, which will be there in a couple of days for you to reference. You can also apply through our website to become a client. And now a brief legal disclaimer. The information that Dave and Jade are going to be sharing with you today is general advice. If you have specific questions about your organization, please reach out to your PBPA attorney. Thank you. And Jade, I'll hand the mic over to you.
Thank you. And good morning, everyone. I want to thank the Pro Bono Partnership of Atlanta for having Dave and I. As was mentioned, my name is Jake Gilstrap, and I practice labor and employment at Seyfarth Shaw. My practice includes primarily defending small, medium, and large-size companies and organizations, and I focus primarily on single plaintiff discrimination cases, which runs the gamut of all types of discrimination: race, sex, gender, religion, pregnancy, that have been brought under state, federal, and local laws, as well as defending companies against wage and hour complaints that have been brought, generally that have to do with unpaid overtime or compensation that might be brought on a single plaintiff scale or on a collective or class action basis. So in my experience in this space, I've gotten to see firsthand the impact that these types of claims have on organizations. So you might be wondering what the number on the slide represents. Well, that 36 to 53%, that represents, the percentage chance that a small organization might have to defend against a lawsuit. So Forbes conducted a study in 2014 that showed 36 to 53% of all small businesses, and that's businesses that have 500 or less employees, will potentially face a litigation, a charge of some sort in the course of any given year. The next slide, $160,000. That number represents the average cost that a discrimination case will cost an organization through the defense and settlement cost. So that's the cost that it would cost you to get through defense to the settlement stage. And this figure just illustrates how severe, the severe impact that cases and claims like these can have on the bottom line of an organization. And it's important to keep in mind that this amount only pertains to employment charge activity with the EEOC and state counterparts. This number came from a 2017 representative study conducted by Hiscox, an insurance company, that assessed a little over 1,200 closed discrimination cases that were reported by small and medium-sized employers. Also, that number covers employers that have less than 500 employees. So it's important to keep in mind that this number doesn't even reflect all all cases. This is strictly discrimination cases that have been brought, in the EEOC space or a state counterpart. So it doesn't even get into the territory of Fair Labor Standards Act cases and other employment-related cases that a company might face. And I just want to add one thing to that. Another interesting thing that the study found was that on average, it takes 318 days from the inception of a charge to even get to the settlement phase. So you can imagine how much of an impact that also has just in terms of time and money that's spent as well for an organization. 84,254. That number represents the number of workplace discrimination charges that were filed with the EEOC just in 2017. And with that number, $398 million were secured for victims in the private sector and state and local government workspaces through voluntary resolution and litigation. So again, a very startling number just to kind of show the impact that and prevalence that these kind of cases are having for employers. So applicable federal laws. So this slide is important because I wanted you all to be able to see, the breakdown of the federal laws and how it might impact your organization. As you can see, there are certain federal laws that applies to everyone. So you might be thinking, my organization is very small. I don't have to worry about, certain types of claims because I'm not covered by the law. But as you can see, Section 1981 of the Civil Rights Act of 1986, that applies to everyone. And that prohibits discrimination on the basis of race and ethnicity and in contracts. So if you have an employee, you gave your employee an employment contract, you can be sued under that statute. As well as the Uniform Services Employment and Reemployment Act, the Fair Labor Standards Act, the Equal Pay Act, Occupational Safety and Health Act, and the I-9 requirement. So regardless of the size of your organization, you're covered by those federal statutes. And then we move on to organizations with 15 or more employees. At that point, you're also covered under the Americans with Disability Act, Title VII, and the Genetic Information and Non-Discrimination Act. And a lot of claims, particularly a lot of claims that the EEOC sees, fall under those statutes. So even if you don't have 15 employees now, if you're looking to expand, that's something to take into consideration because a lot of claims are brought under those statutes. 20 or more employees, you then add the Age Discrimination and Employment Act as well as COBRA. And then once you have 50 or more employees, the Federal and Medical Leave Act, the Affordable Care Act, and the FLSA lactation break requirements kick in. So it's important to keep in mind that, regardless of the size of your organization, there is a certain level of liability or potential liability at play because there are going to be at least one, if not more, statutes that you're going to be covered by, more than likely. So moving on to the next slide, you'll see this just kind of gives a breakdown of the type of litigation that the EEOC saw in the fiscal year of 2017. As in prior years, the ADA and Title VII, ADA covers disability claims and Title VII discrimination claims. They made up the majority of cases that were brought before the EEOC in 2017. So I think it says for under Title VII there were 98, and under the ADA there were 77. And this is somewhat of an increase in previous years. And then you'll see also that the EEOC filed themselves on behalf of potential victims 184 merits lawsuits into 2017 as well, and that's a double from 2016. So, regardless of the administration that we have, there's been a substantial increase in litigation that's even been brought by the EEOC against companies, and nonprofit organizations are definitely not exempt, as we'll discuss in a little bit. So applicable state laws. So in addition to federal laws, organizations also need to be aware of state laws, and since we're in Georgia, we'll talk about that. But all employers need to be aware that they're covered by the age discrimination statute, the Georgia military leave law, and jury duty statutes that are in place in Georgia. So in terms of age discrimination, having certain provisions for people that are coming back from a military leave or that are in the armed services that need to take leave, that's something that organizations need to be aware of and have to make sure that they're complying with, because there is the potential for litigation in those areas, as well as the jury duty statute. Having certain policies in place that permit your employees to take jury duty or take time to participate in their civic duty there. And then for organizations with 3 or more employees, you have the Workers' Compensation Law. 4 or more employees, the Unemployment Compensation Act. 10 or more employees, the Wage Discrimination Statute. 11 or more employees, the E-Verify requirements. And 15 or more employees, the Equal Employment for Persons with Disability Code. And then the Georgia Sick Leave Law for organizations with 25 or more employees. And I won't go into detail about the extent of each of those statutes or what they necessarily involve, but it's very important just to be aware that they do exist and that your organization might fall under one or more of those laws as well.
Jade, I have a question.
Sure.
If I'm an organization that just has 5 employees,
Mm-hmm.
could I potentially be sued for wage discrimination, something that doesn't apply to my organization, but then end up having to incur litigation costs?
Absolutely. So, you bring up a good point. Just because you might necessarily not fall under a statute doesn't mean that that's going to prevent somebody from bringing a lawsuit against you, unfortunately. And that happens a lot. There's a lot of times where a former employee or a present employee or even a prospective employee might bring a lawsuit against you. And you might be thinking, my organization's not even big enough to be covered under a certain statute that the lawsuit's being brought under. But unfortunately, you're still going to have to defend against that. You can't just say, doesn't cover me, my organization doesn't fall under it, I'm not going to do anything. So you're still going to have to defend against it, which generally means hiring an attorney or working with an attorney to try to have that case dismissed on the grounds that, the organization is not covered under the statute and therefore claims can't be brought. But that still requires you to retain someone, probably to conduct an investigation, see if there's any other claims that are related, because there might be a case where someone brings a claim against you under one statute that's not applicable, but under one statute that is. So that's a very good point. Getting sued anytime is a huge inconvenience and very costly.
Thank you.
So I think we're on local laws, and you'll see that, in the city of Atlanta, there is an Atlanta ordinance for unlawful employment practices, and that pretty much just mimics Title VII, but it adds protections for domestic relationship status, parental status, meaning you can't be denied a promotion because you're a parent. Sexual orientation, you can't discriminate against someone for being heterosexual, bisexual, homosexual. And then gender identity. You can't discriminate against someone based on their perception of themselves as male or female. So those are all things to keep in mind. And, if you have 10 or more employees, you're going to be covered under that ordinance as well. So when it comes to common employment-related disputes, at least in my experience, they tend to fall under 2 buckets: how an employee was treated or how an employee was paid. So under how the employee was treated bucket, you're going to see claims or someone saying, what I experienced was discrimination, or I was harassed, I was retaliated, I was wrongfully terminated. And then you have the instances where someone might be saying that, someone conducted an illegal background check on me. How it was conducted was improper, I didn't authorize it, or even the information that was reported wasn't accurate. So that kind of all falls into that realm. And, now we also have the, a large focus on the Me Too. It's a large focus on disability, pregnancy, discrimination, harassment. And now that we're in the Me Too era, you're going to see an influx of those cases as well. So we have that aspect of it, and then how you're paid. So you're dealing with things like, am I properly paying my employees? Have I classified my employee correctly? Is this employee properly classified as exempt from overtime or non-exempt from overtime? And that, where you'll see the misclassification, that's what that's talking about. Off the clock work. My employees work 9 to 5, but are they coming in at 8:30 and getting started but not getting paid? Are they working late? Are they going home and working after hours, even though, they're not exempt from overtime? So that means that, any hours that they work over 40, they must be paid for. So those are the things that we see a lot, and that's no different in the nonprofit space. Unfortunately, even if you're an organization and you feel like you have a great mission and you're doing awesome things for the community and you're really helping people, that does not exempt you from any of the claims that we see brought against larger companies with thousands of employees. And these are really the two buckets that we see claims fall under. So it's really important to make sure that your employment practices and your policies are really tight, and that they're not holes that can be poked through, because these are the kind of things that we see come up over and over again.
Another question, Jade. If we have a employee handbook that covers these policies, and we follow all of these policies, then are we okay, or can we still be sued?
Again, you can be sued even if you're doing everything, dotting your I's, crossing your T's, everything's in tip-top shape, your policies are sound, you think all your employees are generally happy, you have a very tight-knit community, your employment handbook has been reviewed 10,000 times, every year everyone has signed off on it. Unfortunately, you can still be sued. And that's the unfortunate part. You work really hard to make sure that your practices and your policies are in line with the law, and that you're doing right by your employees. But as we can see, sometimes people just get angry, and people file lawsuits for a number of reasons. Sometimes they're legitimate, sometimes they're not, or sometimes people think that they've been wronged or mistreated, and it might not necessarily be something that is against the law, right? So you might have really sound policies in your employee handbook that you've been following, but that's not going to necessarily prevent somebody from bringing a lawsuit. However, I do think it's extremely important to have a sound employee handbook, because that just adds fuel to the fire when you don't, right? So if you don't have an employee handbook and also someone's bringing a lawsuit, it just makes it that much harder to defend against your case. Whereas if you had a sound employee handbook, then you could at least say, these are the policies that we have outlined, this is how they comply with the law, and the employee, the person that has brought the lawsuit, received and signed an acknowledgement saying that they understood these policies, and you've at least done your diligence to make sure that you have something to rely on. And sometimes I've even seen someone take an employee handbook and try to use that as a sword by saying, for example, you had a progressive disciplinary policy and I was terminated and not in accordance with the policy. This conduct, this type of misconduct wasn't severe enough to terminate me on the first incident. So you have an instance where someone might even use a sound policy and try to use that as a means of bringing, for instance, a breach of contract claim, which is why we always make sure that when we're reviewing an employee handbook, you have that disclaimer that this is not a contractual document that can be relied on by an employee to say, this is a binding agreement and you didn't follow it. So it's always a lot. So it's we always encourage you to seek counsel and make sure your policies are up to date. But yes, unfortunately, it will not prevent someone from bringing a lawsuit against you. So I wanted to go over at least two cases to kind of give everyone an idea of the type of cases that are brought against even nonprofit organizations. A lot of times, especially in the news, you'll hear about lawsuits being brought against larger companies, but it's definitely not the case that nonprofits are exempt from that. And these two examples were brought by the EEOC on behalf of individuals that filed, charges against an organization. So the first one, EEOC versus the Alpha Group of Delaware, Inc. That was a case that was brought in federal court in Ohio in 2007. And the Alpha Group of Delaware provides employment rehabilitation and adult day support services. And they are a 501c nonprofit agency. And in this particular case, the EEOC alleged that female workers were subjected to a hostile work environment, and then the person that brought this to the attention of the EEOC was retaliated against, who was a high-ranking female executive at the organization, was retaliated against for complaining about this perceived treatment, that she was receiving treatment on behalf of herself as well as other women in the organization. So, they went through litigation, and this case settled for $160,000. And just to highlight the significance of that $160,000 figure, that is just the amount that was paid out to, I believe, 4 individuals who were the alleged victims of the discrimination. So that does not cover the cost of defending the lawsuit up until the point in which they settled. And just to provide a little more context, this case was filed in September of 2007 and settled in March of 2009. So it went on for 18 months. And there's a good chance that, a number of briefings were filed. There was a number of interviews, investigation, depositions, and all of those things are very costly. So that's an amount on top of the $160,000 that was paid out to the plaintiffs. So then the second case is EEOC versus Blinded Veterans Association, and that was filed in federal court in the District of Columbia. And the Blinded Veterans Association is an organization of blinded veterans that was established to help other vets and their families meet and overcome the challenges of blindness. And this case involved a wrongful termination and age discrimination lawsuit. So according to the EEOC's lawsuit, the BVA, this organization, had 2 long-standing employees, and one of them was terminated. At the time of his termination, he was 76 years old, and he had worked for the organization for 34 years. And when it was time, when another position became available, he applied for it, and he was not given the position, and he attributed it to age discrimination because the person that received the position was under 40 years old. And the other individual, who at the time was 70 years old, had been with the company for 15 years, and her position was eliminated. She had tried to apply for another newly created position, and which she believed she was qualified for, and she was not selected, and that position was also given to another individual who was under 40 years old. At the end of that case, it settled as well, and the first victim, victim A, claimant I should say, A, was paid $108,000, and the second claimant was paid over $41,000. So again, total settlement costs upwards of $150,000, and that is only the amount that's paid out. That does not include getting to the payout date. So as you can see, these types of litigations are extremely costly. Both of these examples were only in the discrimination space, and as I mentioned before, there are a number of different lawsuits that can be brought under a number of different federal, state, and local statutes. So while, as I mentioned earlier, the average cost for settlement and defense is $160,000. That doesn't begin to cover cases that might be brought against an organization, for example, under the FLSA, which might even be brought on a collective or class action basis, which means that a number of employees can join in the action, which generally means a lot larger litigation costs and potentially settlement costs. So what are my nonprofit's options to minimize these risks? I'll let Dave take it over from here.
Thank you, Jay. That's a great way to frame, I think, the risk for nonprofits, especially smaller ones. Because when we talk to a lot of nonprofits and the smaller ones, I think a lot of them think they don't have the exposure for employment practices. So I think that's a wonderful introduction. Before I get started, I want to thank Pro Bono Partnership for having me here today. It's a fantastic opportunity. Again, I'm Dave Matthews. I'm with Pritchard & Jordan, a principal there, and I work with nonprofits to design risk management and insurance programs. So let's talk about all the different ways, all the different risks that the nonprofits see and how to insure against that. So really everything that Jay talked about this morning is covered by an employment practices policy in the broad sense. And so let's talk a little bit about how nonprofits can do that and what an employment practices policy will cover. I've got here some sample language from a Chubb insurance policy. Many policies have similar coverage definitions, so we'll just kind of walk through what we have here. These policies are going to cover you for wrongful employment acts, and those are defined by the policy. And you can see here breach of employment contract, employment discrimination, harassment, retaliation, workplace tort, wrongful employment decision, as well as wrongful termination. I think Jay mentioned all of those in the examples that you gave. So there's a wide variety of claims against an employer that can be covered by an employment policy. Not everything is, and we'll talk about that in just a minute. So the next slide is, who's covered, and I think that's important. It's a question that I get from a lot of clients. Certainly the organization is covered as an entity, as well as insured persons, and that insured person is defined by the policy. It's going to be the executive or employee of the organization. Typically an independent contractor is covered, at least for the work they're doing for that organization. And then with nonprofits, you want to make sure your volunteers, especially your board members, are covered by the policy. And that's pretty standard language, but I think anytime you're looking at a policy and evaluating that policy, you want to make sure at least those classifications and then anything else that's unique to your organization are covered by the insurance program. So what does a policy typically pay? The policy is going to pay a loss, and that loss is defined, arising out of a claim that's brought against the organization. And compensatory damages are what you outlined in those two claims, $160,000 each were the compensatory damages. Typically are going to cover back pay, front pay, as well as attorney's fees, and that was outside those examples that you talked about. Certainly judgments, settlements, as well as defense costs. And that's just simply the cost of legal defense for the attorneys, like Jade, to handle your claims. Keep in mind that there's going to be a deductible under each of those policies. So as the insurance company and the counsel that they hire incurs costs to defend you, they're going to charge you back that deductible. Once you've satisfied that deductible, it's all on the insurance company. And those deductibles for small organizations can be relatively small. It could be a $1,000 deductible. As you get to a larger organization, it could be $50,000, $100,000. And really large organizations are going to self-insure $500,000 or $1 million of that exposure. So some policy exclusions. Every insurance policy has exclusions in it. Sometimes they're because the insurance company can't insure a particular risk, or they belong insured elsewhere. And so here are some typical exclusions. Certainly if you're applying for insurance, they're not going to cover a claim that you already know you have against you or a suit that's against you. Or even we'll talk to clients that somebody's made an allegation, but they don't have the coverage and they want to buy the insurance. Well, if you already know that somebody's brought a claim or made a demand or is angry with you from an employment type of situation, you're not going to be able to buy coverage to insure that. It's going to be for future acts that you don't know about. Bodily injury and property damage are often excluded because they're covered more readily by a general liability policy. Workers' compensation, you mentioned that, but you're supposed to buy workers' compensation insurance to cover that. Employee benefits, OSHA violations, you talked about wage and hour claims, and that's a huge issue. So the insurance industry has effectively taken the stance that wage and hour are the responsibility of the employer. Most insurance companies are not going to cover wage and hour claims in and of themselves. Sometimes you can negotiate a sublimit of $100,000 for defense costs only, but they're not going to pay the settlement or the judgment in that area. They simply think that the nonprofit should work with their legal counsel to understand how to pay their employees appropriately. And so the insurance companies yet aren't willing to take a whole lot of that risk on. If you're a large organization, you may be able to buy some, but it's really difficult. So wage and hour is something you should be aware of. And labor management relations, typically not covered by a policy, but we don't have a whole lot of union issues when it comes to nonprofits, and certainly here in the South. So that shouldn't be a big issue. Some advantages to buying an employment practices policy. First of all, a lot of them come with an employment hotline. So they'll give you a free hour or two where if you've got an issue that has arisen, you can call a hotline. It's usually a law firm, like Sayforth Shaw, that you can call and you can get a free hour or two how to handle a matter. And so, that's a free service that it will provide to you. It certainly provides legal defense, and usually at reduced rates. So the insurance company teams with a law firm and they negotiate down effectively volume buying. So you will pay less per hour working through an insurance company than you would if you had to hire that attorney by themselves. They've got pre-qualified lawyers. They vet all the lawyers before they put them on their panel counsel. Certainly the insurance company pays the attorney's fees. That's part of the policy. And some policies come with a crisis response or a public relations expense. If the issue is going to get out there in the public and you need some guidance or counseling on how to address the press, the insurance policy will often pay some expense for you to work with those professionals to help you address the situation and address it with the public. So it's a great opportunity. It's got a lot of advantages in addition to just paying the settlements and the judgments. So some considerations to think about and the cost of the insurance company. A lot of times nonprofits buy directors and officers liability coverage. It's demanded by the directors and officers. A employment practices policy can be tied in and bought side by side with the D&O policy. Usually insurance carriers that offer D&O will also offer employment practices. You can tie those policies together. If for some reason you choose not to have a D&O policy or your directors and officers carrier won't provide employment practices, you can buy it on a standalone basis. It's certainly available. Employment practices is available with shared limits. You can share the limits with the D&O tower, or you can buy separate limits. If you choose shared limits, it's usually less expensive because you've got two policies looking at one policy limit versus separate, so you can take a look at both of those and see what works best for your organization. There are a lot of insurance carriers that write employment practices, so that it shouldn't be difficult to find. Ask your broker, they can put you in touch with many of them. One thing you might want to think about to extend the standard policy is to think about third-party extension. Most employment practices policies, the examples that Jade gave, are for employment claims, right? Retaliation, harassment from an employee against an employer. But a lot of nonprofits work with organizations and individuals outside their nonprofit. So those people could also claim sexual harassment or discrimination against the employer. So that third-party extension broadens that policy, so the policy would respond to a non-employee bringing a suit against the employer. Another thing to keep in mind is defense costs do erode the limits of liability. So if you buy a $500,000 limit for employment practices and you have that $160,000 claim, but that wasn't including attorney's fees, right? So you got to add attorney's fees. So that $500,000 limit minus the 160, maybe another 140 in attorney fees, you're down to a $200,000 policy for the next claim. So when you're choosing policy limits, understand that defense cost will erode those limits of liability. Just something to keep in mind.
Dave, I have a question.
Yes.
If I'm a small nonprofit, I have 5 employees, does it make sense that, if they're not going to really sue me, should I be looking into this policy?
I think it's certainly something to evaluate. I don't push employment practices on all clients. I think that it's good for them to understand what the price would be and what the coverage would provide for them. There are probably 50% of employers out there that don't buy this coverage. And there's nothing wrong with self-insuring as long as you understand what the risk is and you're willing and able to finance it effectively. So for some larger companies where they would pay more in premium, if they haven't had an employment practices claim in 20 years, not that they can't have one, but they haven't had one, well, effectively I see that instead of sending that premium to the insurance company, they're keeping it in their coffers to maybe pay for a claim. So I don't think it's for everybody, but I think it's for something that everybody should consider. If you look at the next slide, it kind of also answers your question. You know, here's an example of an employer with 13 employers and their annual premium was $500. So it may not be that expensive. And maybe, I don't think I've ever seen one under $250, but it really may not be that expensive, even for the small nonprofit. And I think there's some advantages there that we talked about. You know, you've got reduced rates on attorney's fees if something comes up. And from what we've seen, we work with for-profits and nonprofits. There's just as much activity in employment practices claims in the nonprofit sector as there is the for-profit. So I don't think that being a nonprofit insulates you from claims. They still happen. They're just as expensive. There's nothing different about the process that we see once the claim comes in for a for-profit or nonprofit. So 3 examples there. We try to tailor these to some of the smaller employers. Obviously, the limit that you buy, the deductible you have, the number of employees, and some other factors will come into play into what the insurance company is charging. So on the next page, some of the underwriting issues that we have. Certainly, the underwriter is going to want to look at an application that the nonprofit will fill out. They'll often ask for a financial statement, want to understand the finances of the organization. An employee handbook we talked about. I think it's imperative for every organization to have one. Make sure it's vetted by an attorney, that they have all the appropriate language in there. Certainly, you know, sexual harassment prevention and all of those types of things. The underwriter will want to look at your organization, see if you had any past claims, so ask about that. That will be part of the application. If you're a new entity, that we see a lot of the smaller nonprofits are, if you don't have a history, a lot of times the underwriters would like to see 2 or 3 years of operating history. If you don't have that, they'll probably ask for resumes of the executives of the nonprofit to see that they've got experience in management and leadership. So that will be one of the key things they'll look at. So that's the underwriting process. Takeaways, I think we've talked about this. No matter if you're a for-profit or nonprofit, litigation can happen. It can happen really to anybody. I think an insurance policy is a great opportunity to protect your balance sheet and protect your organization, and it's got some great advantages for an organization to look at. So if you don't have coverage now, I would look at the cost and sit down with your finance committee or board and see if it's appropriate for your organization. Thank you.
Questions? I don't see any more questions being typed up currently. So thank you, Jade. Thank you, Dave, for speaking today.
Thank you
Great to
for
be here.
having
Thank
us.